Participants and the aspirants of the JCJ 2023, which is going to be held on the 7th January 2023 if it is not postponed. And today is the second class of the Hindu Marriage Act 1955. And without the wasting the time, then I will go directly to my question. Yes, participants, be ready. Yes, the 16th question. Post Supreme Court ruling 2022. In January 2022, the Apex Court, through its decision in Arunachal Gaundar, within parenthesis dead, versus Pannuswamy, held that the self-acquired property of a Hindu male dying intestate should devolve by dash and not by dash. So the first option, choice A, self-acquired property and ancestral property. B, ancestral property and self-acquired property. C, succession and inheritance. D, option, inheritance and succession. Now the suit, which one is the appropriate word among the A, B, C, D?
C, I think so, if I'm not mistaken.
Say loudly.
In this case, C, succession and inheritance.
WRONG, wrong. Second option.
Then we both only have to keep on saying.
The second option.
Inheritance and succession?
Yes, it is inheritance and succession. They are the suitable words in the place where
I reversed it.
Arunachala Gaundar versus Pannuswamy. There is a self-acquired property of Hindu male dying intestate would devolve by inheritance and not by succession. So that is the wording could be there. So now next question, 17th question. Can anyone unmute and read the participants? Sridevi, Jay, could you unmute and read the 17th question? Sir, just now I joined. Let the other people will read it.
The court
Read it,
observed.
Sridevi.
Sir,
17th question.
the court observed that the basic aim of the legislature in enacting of Hindu Marriage Act is to ensure that the inherited property of a female Hindu dying issueless and intestate go back to the source. Option A, section 15, subsection 1. Option B, section 15, subsection 2. Option C, section 15, subsection 3. After D, section 15, subsection 4.
Shoot, which is the appropriate answer among the ABCD options or choices? There is no negative marks. Apply your logic.
15 subsection 4, sir, D.
WRONG. Second option.
Option A, 15 subsection 1.
WRONG. Third option.
Option C.
WRONG. Then what is the right answer?
Option B, 15 subsection 2.
You are right. It is a section 15 subsection 2 is the appropriate answer for the 17th question. So now the 18th question. Prior to this deliberation, the Supreme Court on August 11, 2020 also expanded on a Hindu woman's right to be joint legal heir and inherit the ancestral property on terms equal to the male heirs in the case of dash. Observed.
Vinita Sharma versus
Sriya
Rakesh Sharma.
Sarda. Let me finish the total options, then you can shoot. A. Sistia Sarada Devi versus Uppaluri Hari Narayana and others. B. Vinita Sharma versus Rakesh Sharma and others. C. In SMT, VL Jayalakshmi versus VL Balakrishna and others. D. Prakash versus Pulavati. Yes, now you can shoot among the ABC.
D. Vinita Sharma versus Rakesh Sharma.
Yes, you are right. It is a Vinita Sharma versus Rakesh Sharma and others. In this case law, the above statement was made.
Landmark judgment. It's the landmark judgment.
Yeah, you are right. You are right. I appreciate. Then the 19th question. Which option is true in the following options? 1. Suppose a Hindu makes a will or make a disposition of property in favor of a son according to the Hindu Section Act 1956 and not the daughter. 2. Then the daughter will not be able to question the will and not claim benefit of the Supreme Court judgment. 3. But if a Hindu dies intestate without making any disposition of property, then the daughter don't have the right to claim an equal right of inheritance. Option A, 1. Option B, 1 plus 2. Option C, 1 plus 3. Option D, 1 plus 2 plus 3. Shoot, which one is the right option among A, B, C, D?
Option A. Option A.
WRONG.
1.
Second option. What is the second option?
Option C. 1 plus 3.
WRONG. Third option.
Option D.
WRONG. Then the right answer is
Option B, 1 plus 2.
1 plus 2. Why the right answer? I will give the feedback here. See, number 1 clearly says, suppose a Hindu makes a will or makes a disposition of the property in favor of the son according to the Hindu Section Act 1953 and not the daughter. A person wants to make the will to whom that he would like to make it out. And then come to the number 2, then the daughter will not be able to question the will and not claim the benefit of the Supreme Court judgment. A judgment is given earlier. But the B is, if a Hindu dies intestate without making any disposition of the property, then the daughter don't have the right to claim an equal right of inheritance. And here the feedback is, if a Hindu dies intestate without making a disposition of the property, then the daughter have the right to claim an equal right of inheritance if there is no will. Is it clear? Here I made
So what is it?
don't.
So,
Here I made don't.
So, sir,
Yes.
let the participant answer, not you. So what is the difference between interstate and testamentary? Testamentary. Interstate and testamentary. What is the difference?
Participants, give the answer.
Testamentary is a will, sir. Example.
Okay. Interstate?
Without making.
Without making a will, why do you keep the doubts? Is it
Testamentary
clear?
is making a will and interstate is without making a will.
Yes. So that is the difference between the testate and intestate. Now, either you testate or intestate anything, especially the will, it will operate only when the testator is no more. Is it clear?
Yes. From the day when he dies.
Yes. 20th question. Which option is true in the following options? Number 1. Daughters will now be treated as par with the sons of co-partners and granted equal co-partnership right in their father's property upon birth itself. Number 2. Daughters shall remain co-partner throughout their life irrespective of whether their father is alive or not. C. Hence, even their marital status will not affect the right of conferred to them by way of amendment, and hence they shall continue to be the part of their father's HUF post-marriage. That is a Hindu undivided family post-marriage. Option A, 1 plus 2. Option B, 1 plus 3. Option C, 2 plus 3. Option D, 1 plus 2 plus 3.
Option D, 1 plus 2 plus 3.
You are right, Sri Devi, this time, because all are correct now. Daughters will now be treated as par with the sons co-partners and granted equal co-partner right in their father's property upon the birth itself. Next is whether the father is alive or not doesn't make any difference. The next point is whether daughter is married or unmarried. It doesn't matter if their father's HUF post-marriage is there. So answer is 1 plus 2 plus 3 is the right answer for the 20th question. Shall I proceed? Say yes.
I have one more
Yes.
question.
Yes, please.
Once a will is executed,
Yes.
let me put it a very simple way.
Yes.
X makes a will and he dies. So, how are you going to execute a will? By what means?
How a will can be administered to the beneficiaries or legacies or legati. There is a probation is there, you don't know, administrator is appointed over there.
There is a
Receiver-
probate. The probate is applicable in 3 cities only:
Yes, that is
Delhi,
Madras.
Calcutta, and Madras.
Yes.
In rest of the cities, no, sorry, not Delhi, Mumbai, Calcutta, and Madras. In
Okay.
rest of the cities, probate is not allowed. It is not
Okay.
applicable.
Okay.
Only will can be go for execution.
Yes.
And the fees for the execution for a probate is 75,000 rupees maximum.
Okay. Who can apply?
On whose name the will is given, he has to make an application.
Suppose there is no one person is there to execute the will, then
Will किसका नाम पे बना है? किसके नाम पे तो बनाया होगा ना?
okay, that fellow is died.
The will die is legal, it will come into picture then.
Can't they approach to the court, the legacies or the beneficiaries or the legal heirs to appoint the receiver to see that the property will be distributed as per the Hindu Marriage Act? Sorry, as per the succession?
No. Once a will is made, it has to go according to the will.
Okay.
If not, the state will acquire the property.
Okay. Okay, now let us see the 22nd question. Silent features of the Hindu marriage laws. Number 1, a Hindu by birth or by conversion is the subject of the Hindu Marriage Act of 1955. Number 2, the definition of the Hindus under the HAM Act includes Buddhist, Jain and Sikhs as well. 3, customary practices within parentheses, customs, long-term usages, riti rivaj are well respected under the Hindu Marriage Act of 1955. Option A, 1, option B, 1 plus 2, option C, 1 plus 3, option D, 1 plus 2 plus 3. I would like to see how that you can make it out.
Option D, 1 plus 2 plus 3.
Wrong. You closely observe and you will get the answer.
1 plus 2, option B.
Wrong. If you closely observe, there is some mistake in the 2. The definition of Hindu marriage, Hindu under the HAM. Is it HAM?
HMA.
HMA, that is number 1. Number 2, HMA means act itself is there. Then why again writing the act here? Number 1, there is a mistake. I did not write HMA. Okay, if I write HMA also, I should not supposed to write act. So the second is not applicable. Am I right?
Yes, sir.
Then which is the right answer?
Option C, 1 plus
Option
3.
C is the right answer. See the feedback. The definition of Hindu under the HM Act, not HMA. HM means Hindu Marriage Act, includes Buddhist, Jains and Sikhs as well. So this is my creation. They may confuse you because in the examination you don't see whether it is properly written the initialism or not, and you will definitely will tick 1 plus 2, but actually 1 plus 2 is not the right answer. Is it clear?
Yes, sir.
Okay. 23rd question. Hindu Marriage Act 1955 is the answer to the following question, which is the right option or choices. Because Hindu Marriage Act answer all these points, but which is the correct, exactly the option among the choice are concerned. Number 1, who is a Hindu for marriage under the HMA Act? Actually, we should not supposed to write A here. Okay, let us see that. What are the marriage rules between the Hindus? 3. What is the age of marriage in India in 2022? And C. Can I do second marriage without divorce in India? So here I am giving the answers. Option A 1 plus 2, option B 1 plus 3, option C 1 plus 3 plus 4, option D 1 plus 2 plus 3 plus 4. Now you apply the analogy what I discussed earlier, then you can shoot the right answer. Even though there is no negative marks, try. See, number 1, who is a Hindu for a marriage under the HMA Act? The HMA Act clearly gives the answer for that one. Is it clear?
Yes, sir.
Okay, that means 1 is acceptable.
Option
Then what are the marriage rules between the Hindus? It also clearly stated. Is it
section
stated?
5.
What are the marriage rules between the Hindus? Is the right way? Observe closely. We should not say between Hindus, among the Hindus. Am I right? Am I right? You are supposed to say what are the marriage rules among the Hindus. That is the appropriate word. That means we can eliminate 2. Is it? Say yes or no.
Yes,
Between
sir.
is only 2. Among means many. So what is the age of marriage of India in 2022? Yes, it's the Hindu Marriage Act clearly says.
Bridegroom 21 years, bride 18 years.
Yes. Can I do second marriage without divorce in India? It gives the answer. If you do it, you will come under the which
No,
offense
sir.
will committed. When a spouse is
Bigamy.
when a spouse
Bigamy.
is living and you have gone for the second marriage, then what offense is committed?
Bigamy.
What is the section?
494.
Appreciate.
guess.
So here, what is the right answer?
1.
1 plus 3 plus 4 is the right answer.
Okay, I differ from the 4th point.
Yeah.
Can I do a second marriage without divorcing the first wife?
Yeah, it clearly says it is an offense under the Hindu Marriage Act, Bigamy 494. So,
But I
Hindu
differ with
Marriage Act, give the answer. I say answer here. Did you
Not yet completed.
see the question? Hindu Marriage Act 1950 is the answer the following questions.
सर आप मेरा सवाल तो सुन लीजिए सर.
Yes.
I said I differ from the point number 4. Can a second marriage without divorcing in India is legal? I said it is legal as per Hindu Marriage Act.
Give the explanation.
I'll give you a judgment of Bombay High Court of 30th November 2022.
Okay.
The Bombay High Court clearly said a Hindu can marry a second wife when the first wife is living with the consent of the first wife. That amounts to
What
cruelty.
is there? Yes, if she cannot conceive it, she will give the consent because they want to be a progeny, and the special circumstances they can make it out so.
No. There is not that.
Anyway, no debate. Here the only options are given, you have to pick it out. Only options are given, you have to pick it out. Okay? Shall I proceed?
Yes, sir.
Good.
Yes, sir.
Yeah. See, there is no question and debate because every rule having its exceptions. You can abort the child. It's illegal when the mother's health is going to be endangered, number 1. Number 2, the fetus will not be grown up. At the time, you can go for the abortion. So there are special circumstances to be there. Yes, the fetus can be aborted. And that to be within 3 months of conceiving. And if an extraordinary cases also can be done when it is harmful to the fetus as well as to the mother. So that is another point. Okay. 24th question. Hindu Marriage Act 1955 is the answer to the following questions. Which is the right option or the choice? Number 1. Can a man marry 2 wives legally? Number 2. Is marriage another caste legal in Hindus? 3. What are the Hindu Marriage Act divorce process? C. Can people of other religion marry through pheras, saptapadi? Options: A plus 3, B 1 plus 2 plus 3, C 1 plus 2 plus 4, D 1 plus 2 plus 3 plus 4. I ask the question, please read. Whether the Hindu Marriage Act 1955 answer the following. As S.R. Venunath said, in the special circumstances, yes, by the consent of the first wife, a Hindu can marry the second wife also. Number 1, answer is given.
Option D, 1 plus 2 plus 3 plus 4.
Here the right answer is 1 plus 2 plus 3 plus 4 is the right answer. Is marrying is another caste legal in Hindus? Yes, it is illegal. Is it necessary that 2 men should be the Hindus? Can't you marry a Muslim or a Christian or a Jew? It gives the answer. So hence, where the Hindu Marriage Act divorce process is there, yes, it is there. And can the people of other religious marry through the pheras? Why not? If you want to convert into Hinduism, yes, Saptapadi is there. And another word also I used in my last class. Can you tell me what is that word? Saptapadi and I gave the one word. Can anybody remember?
Ceremonies, customs.
No. There is another word I used over there. Kerva. Kervas. Kervas. That is the wording that I used.
Yes.
Okay, 25th question. Salient feature of the Hindu marriage laws. Which option is true? Number 1. The concept of divorce among the Hindus was introduced through the Hindu Marriage Act. Here A is an extra. We should not supposed to write it. It is also, number 2, it is also brought an end to the customary practice of bigamy, polygamy, or the polyandry, that is the multiple marriages. 3. Registration of Hindu marriage is subject to the laws applicable in particular states. However, the marriage is not invalid or illegal due to the lack of an official certificate. 4. Here I should have to keep it. Otherwise it is wrong. Okay. 4. Matters of Hindu marriages and divorce follow the procedures in the family court in India. And option is given in 1 plus 2, B 1 plus 2 plus 3, C 2 plus 3 plus 4, D 1 plus 2 plus 3 plus 4.
Option C, 2 plus 3 plus 4.
Yes, because we should not suppose to write HMA, because HMA, A itself is Act, and hence HM Act only that you are supposed to write it. Hence, the answer is 2 plus 3 plus 4 is the right answer for this question. Sometimes they may also make such a trick, and they will ask you, and they will say whether it is right or wrong. So I want to see in the initial point of view or in the grammatical point of view also. Like I told you in the earlier, between the Hindus, no, it is among the Hindus. The concept of divorce among the Hindus was introduced through the HM Act, not HMA Act. HMA itself Act has come, then there is no necessity of the Act. That means there is a mistake over there. Is it clear? Say yes.
Yes, sir.
Now 26th question. Salient feature of Hindu marriage laws. Which option is true again? Number 1. Matters under the Act are taken by the courts of the territorial jurisdiction, that is the city or town where the marriage was celebrated, where one of the party resides, or where the husband and wife last resided together. Number 2. Unlike any other matrimonial laws in India, the HMA Act, of course, again I committed a mistake here, okay, also contains the provision for the restitution of the conjugal rights, RCR, So if one of the spouse leaves the other without any reasonable excuse, such other spouse may reach the court for the restoring the matrimonial relations and bring back the spouse. Consultation with the divorce lawyers in Kolkata will help in the, of course, this is the extra thing, we need not worry. And a marriage is voidable, legally invalid from the beginning if it is a bigamy or subinda or prohibited relationship. And the four subinda relations include 3 generations in the mother's family tree and 5 generations in the case of the father family tree. That is, X is a girl and Y boy is the first cousin of the ex-mothers. They are subindas to each other, thus prohibited from marrying. So now, among the 4, you can choose whether 1 plus 2 is the right option, or the B, 1 plus 2 plus 3 is the right option, or C, 1 plus 2 plus 4 is the right option, or 1 plus 2 plus 3 plus 4 is the right option among the 4.
Option C, 1 plus 2 plus 4, sir.
Option C is the right answer, 1 plus 2 plus 4, because 3 is a marriage is not voidable, void, legally invalid from the beginning if it is bigamy, subinda or prohibited relation. So here the feedback I have given. A marriage is void, not voidable, legally invalid from the beginning if it is a bigamy, 494, subinda, that is a prohibited relationship. Is it clear?
Yes, sir.
What is subinda? The close relationship between the people, the same father, same mother, do they marry?
No, no, no.
Then what is subinda? At least can you tell me? Here I will give the answer. Because
Nephew, niece, mama, all these people.
no, how do you define subinda?
Oh, sorry.
A person considered in relation to any of his or her 3 or sometimes 6 nearest lineal male ancestors or descendants. Like what is Sapinda under the Hindu law? It is clear. Sapinda relationships are prohibited under the Hindu marriage law. A Sapinda is someone who is within or has common ancestors, relatives within 3 generations above you or on your mother's side of the family, within or has a common ancestor relative within 5 generations above you and your father's side of the family. These are the people are called Sapindas. Is it clear? If they ask the Sapinda meaning also, they have given, and they will ask you, father side how many generations and mother side how many generations. Here it is given 3 generations in the mother's family tree and the 5 generation in the case of father family tree. So supplementary question, they can put either 3 or 5 or 2 or 5 or whatever it may be. So here the valid is a marriage is void in the beginning because it is a bigamy. When the spouse is living, if you could go for marry, and subinda or the prohibited relationship. Now 27th question. Salient feature of the Hindu marriage law, within which option is true? 1. Prohibited relations include certain relations that are prohibited from marrying each other. These include brothers and sisters, brother's wife, uncle, niece, etc. These include full blood, half blood, and relation through the adoption as well. Number 2. To put an end to the marriage, understanding divorce versus legal separation is important, while legal separation is a period and the divorce is a full stop to marriage. And 3. A marriage is voidable, may be declared invalid and null or on request of one of the parties, and certain cases as explained below in detail. And 4. Hindu Marriage Act 1955 Section 13 provides for the various grounds on the basis of which divorce can be granted to one of the spouse if another does not agree to separate. There are special grounds that are specifically allow the wife to seek divorce from her husband's side. So among the 4 options, which one is the right option? I mean, correct one. Here I have given the, oh, I have not given A plus. Yes, now you can see whether A1 is correct or A plus 2 is correct, A plus 2 plus 3 is correct, or A plus 3 plus 4 is correct, or 1 plus 2 plus 3 plus 4 is correct. You tell me among these four. See, if you closely watch it, A is right, no doubt at all. Am I right?
Yes, sir.
And if you closely watch number 2, put an end to the marriage, understanding divorce versus legal separation is important. Now, while legal separation is a period and divorce is a full stop to marriage, there I committed
Yes, sir.
I wrote a wrong way. Can you tell me what is the right way of writing?
Judicial separation.
No, here, while legal separation is, no, we can say judicial separation or legal separation. Is a, I wrote period.
Comma.
It is a comma actually. Legal
The comma and
separation is
divorce
a
is a full
comma
stop.
and a divorce is the full stop.
Yes.
That is actually the word. But instead of writing comma, I wrote the period. Period means again the full stop. It's a synonym for the full stop is period. So here I committed the mistake, and that's the reason I wrote here to put an end to the marriage. Understanding divorce versus legal separation is important. While legal separation is a comma and divorce is a full stop to marriage. So such a technical also they can ask you in the examination. Hence, my student should not keep the zero face, a withered face, a pale face in examination hall. They should be a dynamic like a lion or lioness. Okay, 28th question. Salient feature of Hindu marriage law, which option is true? Number 1. Although the parties are legally not allowed to seek divorce within 1 year of marriage, in general, I am speaking, they can go for the judicial separation. However, a divorce may be granted before the completion of 1 year in special circumstances of exceptional hardship. Okay. Number 2, if one spouse is alive and the person remarries, such a marriage is not only void, but the person also punishable under the section 494 and 495 of the Indian Penal Code 1860. And 3, marriage among minor is punishable with the imprisonment up to the 3 years and or fine up to the 1 lakh. And the 4th, marriage among sub-in-laws prohibited relationship is not punishable with the imprisonment of 1 month or fine up to 1,000. The relationship can be easily understood with the help of the divorce attorney. So I made the 4 options here. Then first option is 1 plus 2, second option is 2 plus 3, and C 1 plus 2 plus 3, and the third option is, D option is 1 plus 2 plus 3 plus 4. Now if you observe closely 1, 2, 3, 4, where the fault lies?
Option B, 2 plus 3.
Option C is the right answer here. 1 plus 2 plus 3 means fourth one is wrong.
Can I say something?
Yes, please.
Recently, the Kerala High Court has
No
struck
debate,
down
no debate, no debate. Only 1, 2,
Yes,
4,
only for
5.
knowledge. Only for knowledge, sir. नहीं बोलना था, I will not tell anything.
Okay, please tell.
Line this up.
No, you can proceed. You may proceed if you want to add some other thing. But here, only 1, 2, 3, 4, you have to make the point.
Option B, 2 plus 3, sir.
No. Here, I made the marriage among the sub-in-laws or prohibited relation is not punishable, but actually it is punishable. Is it clear? Here, prohibited relation is not punishable, I said, but actually it is a punishable. That is the point. So that is the reason that I have given 1, 2, 3, 4. Among it, we have to select it. Is it clear?
Yes, sir.
Yes. So that is the point. See, we have to choose from the answer which is given over there. So additional knowledge, okay, we can make it out. But here we have to clear what is the right way. Okay. The next, 29th question. Conditions for valid marriage under the HMA Act Section 5 of the Hindu Marriage Act provides condition for a Hindu marriage which have been explained below, especially what age of majority should be completed and what the exact wording given by the HM Act 1955. Number 1, free consent. Both the parties should be mentally stable to give their consent for their marriage. Second, age of majority. The minimum age for the marriage for 18 years for the woman and 21 years for the man. And 3, sub-in-law relations. Marriage between the bridegroom and a bride who is related to through a mother up to the 3 generations and father up to the 5 generation is not valid unless the customs allows it. And C, prohibited relationship with the bride and bridegroom fall under the prohibited relations and such a marriage is invalid unless customs allow it. I said conditions for a valid marriage under the HM Act. That is Section 5 of the Hindu Marriage Act provides what are the conditions should be there. Explained below. Especially what the age of majority should be completed with exact of the wording. What exactly the wording used in the HM Act. That wording should be used over here.
18
So,
years for bride,
yes.
21 years for bridegroom.
Yes, that is the point which is. So the right answer is
C, 1 plus 3 plus 4.
that is a C is 1 plus 3 plus 4. The exact wording will be there. It is the wording is not women. 18 years for the bride and the 21 years for the bridegroom. That is the exact wording used in the Hindu Marriage Act. So that is the point which we want to make it out. That is the reason what are the selected. What are the options are given over there? From there only you have to select it and give the explanation for that answer. So here the bridegroom has completed the age of 2, that is 21 years, and the bride age is 18 years at the time of the marriage. So that is the exact wording. So 30th question, match the following section from part A and an explanation given in the part B of the following. So part A, section 9, Section 10, Section 11, Section 13. Part B, A, void marriage, B, divorce, C, restriction of conjugal rights, and D, judicial separation. And here I have given the options. A, 1C, 2D, 3A, 4B, B, 1B, 2D, 3C, 4A, C, 1D, 2B, 3C, 4A, D, 1C, 2B, 3A, 4D. Which one is the right answer for this one among the A, B, C, D?
Option A.
Yes, you are right. It is an option A is the right answer because section 9 is the restriction of conjugal rights, section 10 is the judicial separation, section 11 is the void marriage, and section 13 is the divorce. So here the 1C, 2D, 3A, 4B is the right answer for that one. Now 31st question. Voidable marriage under the HMA Act. We should not write HMA Act because it is a wrong way. HM Act 1955. Which option is correct or true among the options are multiple choice questions. Number 1. A marriage is otherwise legal and valid but can be declared illegal by one of the parties to the marriage. Such condition for voidable marriage under section 11 of the Hindu Marriage are as follows. Okay, number 2. If one or both the parties were minor, that is below 18 or 21 years of age respectively at the time of the marriage. 3. Marriage is not consummated like a first sexual intercourse because one of the spouse is impotent. And 4. If the wife was pregnant by someone other than her husband at the time of the marriage, the husband can seek annulment of marriage. So these are all the 4 conditions which I have given over there, and which one is acceptable and which one is correct among A, 1 plus 2, B, 2 plus 3, C, 2 plus 3 plus 4, D, 1 plus 2 plus 3 plus 4.
Two plus 3 plus 4, C.
Yes, it is a 2 plus 3 plus 4 is the right answer. But what is the wrong in one? A marriage otherwise is legal and valid but can be declared illegal by one of the parties to the marriage. Such condition for the voidable marriage under section 11 of the Hindu Marriage Act are as follows.
Void marriage. Void marriage.
Section 12 of the Hindu Marriage Act, not section 11 of the Hindu Marriage Act. A marriage is otherwise legal and valid but can be declared illegal by one of the parties to the marriage. such condition of the voidable marriage under the section 12 of the Hindu Marriage Act, that is not section 11 of the Hindu Marriage Act. Is it clear? Here I have given 11 of the Hindu Marriage Act in the option 1. Did you see it? Say yes.
Yes, sir.
And here section 12 is the right answer for that one. Is it clear?
Yes, sir.
Very good, appreciate. So 32nd question, which statement is true? Number 1, the Hindu Marriage Act put an end to this discriminative cycle by introducing the concept of divorce. Number 2, the Hindu Marriage Act 1955 section 13 explains the dissolution of marriage through the divorce. Section 3, keeping up the Hindu notion of the permanence of the marriage, the law are so liberal for the grant of divorce. Number 4, there are various grounds that need to be satisfied in case one of the parties is willing to separate while other wishes to continue the marriage. Among the 4 options, which option is wrong? Here I have not given the option. Number 1 plus 2 or 2 plus 3 or 1 plus 2 plus 3 or D 1 plus 2 plus 3 plus 4. Which one is the correct option?
Two plus 3 plus 4.
Then what is wrong in the 3? Is it wrong in the 3 or wrong in the 2? Let me see the feedback. 3. Keeping up the Hindu notions of permanence of marriage, the law are not so liberal. But here I said 3. The laws are so liberal. Not I removed. The laws are so liberal for the grant of divorce. No, Hindu Marriage Act laws are not so liberal. It is are not so liberal. Is it clear? You cannot get the divorce within no time. No. At least you should wait for 1 year from the date of the marriage. And special circumstances, that is a different issue again. But in general, and once the decree also given, you have to wait for the appeal. Are you following me? That means
Yes, sir.
getting divorce is not so easy, even though the mutual consent will be given. What the section says, mutual consent of the marriage, divorce can be given.
Section 13B.
Yes, that is I am going to ask in the next question. Which is the correct or exact sequence? I am asking the sequence, which come first, which come later. Number A, restitution of conjugal rights, divorce, judicial separation, divorce by the mutual consent. B, judicial separation, restitution of conjugal rights, judicial separation. Oh, I repeat it again. So, divorce by the mutual consent. C, divorce, judicial separation, divorce by mutual consent, and restitution of the conjugal rights. D, restitution of the conjugal right, judicial separations, divorce, and divorce by mutual consent. Which one is the appropriate here?
D.
Option D.
If you say option C, it is wrong.
D, sir. D, sir.
Option D, if you say, is the right. The sequence is the first, restitution of conjugal rights, section 9, judicial separation,
Section 10.
divorce,
13.
Section 13.
divorce by mutual consent.
13B.
13B.
Professor Hussain students never say 13B. What do they say? Section 13 capital B.
Section 13 capital B.
So here I have given the feedback. 9 is the restitution of conjugal rights and 10 is the judicial separation, and judicial separation is a comma and divorce is the full stop or period, and the 13 is the divorce and 13 capital B is the divorce by mutual consent. Is it clear?
Yes.
Yes, sir.
Okay, 34th question. In case both the husband and wife are willing to separate, number 1, HMA section 13A provides the mutual divorce as well. HMA 13 capital B provides the mutual divorce as well. 3. Parties cannot seek divorce within 1 year of marriage. 4. Parties are allowed to marry only after the end of the period of the appeal after the divorce decree is granted. See, here the options I made the difference way. A. 1 plus 2 plus 3. B. 2 plus 3 plus 4. C. 1 plus 3 plus 4. D. 1 plus 2 plus 3 plus 4.
Option D,
Option
1
B.
plus 2 plus 3 plus 4.
Yes, you
Option
are right. It is option B. That is 2 plus 3 plus 4. What is wrong? In one,
Option 1.
it is section 13 capital A is the wrong.
Yes.
So that way you have to be very much careful before you are filling the blanks and choosing the option. So feedback here I given is HMA section 13 capital B provides for the mutual divorce as well. So that is the way of say. So 35th question. Before dash, a guardian had to give consent on behalf of the child getting married. Option A, 1975. Option B, 1976. Option C, 1977. Option D, 1978. Which one is the appropriate option?
1976.
Wrong.
1975.
Wrong.
Wrong, no, sir.
The right answer is option D, 1978. Before 1978, a guardian has to give the consent on behalf of the child getting married. 36th question.
Okay.
Shall I proceed?
Yes,
Yes,
sir.
sir.
36th question. Appeal. Can anyone has taken the screenshot when the maximum members are there? So day by day, the people are decreasing or increasing. Even one student also there. It is my commitment that I will deal in the same manner as if 100 students are there. It is my attitude. Either you can say it is an exaggerated attitude or a positive attitude or a negative attitude. So 36th question. This appeal raises an issue of the great importance to the well-being of the nation as it goes to the very root of the marriage relationship. The husband petitioned for the restitution of the conjugal rights. The wife opposed it. The additional district judge granted a decree of the restitution of the conjugal rights to the husband. From that decree, the wife appealed to the court in the case of, in which case the court appealed the wife? A. T. Yes, just a minute. A. T. Sarita versus T. Venkata Subbaya. B. Haravinder Kaur versus Harmander Singh Chaudhary. C. R.S. Joshi versus Aziz Mills. And D. Anne Saheb versus Tarabai.
Option A.
Option A, Sarita versus Venkata.
No, the Sarita versus T. Venkata Subbaya, they said a woman can have a right to deny for the conjugal rights because Sarita is a Telugu actress.
Harvinder
Option
Kaur
B.
versus.
Option B, Harvinder Kaur versus Harvinder.
Yeah, the judgment of the Sarita is reversed in the Harvinder Kaur versus Harminder Singh Chaudhary. Venuna, do you want to add any comments on this one? On the T. Sarita versus T. Venkata Subbaya case law, if you are read it. Okay, the reversed in the Harvinder Kaur versus Harvinder Singh, and hence the Supreme Court, the appeal court has confirmed the trial judge. Yes, the husband is having a right to file a conjugal rights because without showing the actual reason for not staying together is it should be shown over there. If the reason is not appropriate, then the court will definitely ask for the restitution of the conjugal rights. So that was the case decided in that Harvinder Kaur versus Harvinder Singh Chaudhary. So now the 37th question. Can a Muslim may marry under the Hindu Marriage Act 1955? Answer. A.
No.
Yes. B. No. C. Yes under the Special Marriage Act 1954. D. A plus D.
B. Option B. No.
Option B.
Option?
B.
B.
It is A plus D. Means
No.
under Special Marriage Act, a person can go marriage because it is a casteless marriage. It is a casteless or caste-free marriage. Irrespective of the caste, that is the wording. So applicability is there. Any person, irrespective of the religion, Hindu, Muslim, Buddhist, Sikh, Christian, Parsis, Jews can also perform marriage under the Special Marriage Act of 1954. Inter-religion marriages are performed under this act. So, supplementary question. Who is the Bollywood actor married under the Special Marriage Act? Sir, Dharmendra Hemamalini. No. They converted it, they get married. Who is the Bollywood actor and who married under the Special Marriage Act? If you don't know, you say pass on. Are you hearing me? Are you hearing me?
Yes, sir. Yes, sir.
But why you are keeping quiet? Say pass on if you don't know.
Pass, sir.
Veruna, do you want to comment on this one? It is the Saif Ali Khan, the son of Patodi, the Sharmila Thakur's son. Saif Ali Khan married to whom?
Kareena Kapoor.
Yes. And there are a Special Marriage Act, they married together. That is a supplementary question. Now, 38th question. What other acts were passed with the Hindu Marriage Act? Other acts, still 5 minutes are left. Number 1, the Hindu Succession Act. Number 2, the Hindu Minority and Guardianship Act. Number 3, the Hindu Adoption and Maintenance Act. Number 4, the Special Marriage Act. Options: A plus 2, B 1 plus 2 plus 3, and C 1 plus 2 plus 3. Oh, he repeated. D 1 plus 2 plus 4.
Option B 1 plus 2 plus 3.
Yes, is the option C. Actually, I should have supposed to say here. It is a 3, it should be the 4. It should be the 4. Then option is 1 plus 2 plus 3 is the right option. Because the Special Marriage Act is passed in which year?
1954, before
Yes,
Hindu
that is the
marriage.
reason with the Hindu Succession Act 1956, the Hindu Minority and Guardianship Act also later, the Hindu Adoption and Maintenance Act also later. Means before 54, 55 is only the Special Marriage Act 54 is passed. So here I am giving the feedback. The Hindu Marriage Act is an act of the Indian Parliament that was approved on the May 18, 1955. The Hindu Succession Act 1956, the Hindu Minority and Guardianship Act of 1956, and the Hindu Adoption and Maintenance Act of 1956 were all enacted all this time as the part of the Hindu Code bills. So the right answer is 1 plus 2 plus 3 is the right answer for the above 38 question. So with this, today's Hindu Marriage Act of 1955 class is over, and the next class is, what is the next class? What we are going to study tomorrow and after tomorrow?
Indian Evidence Act.
I put it on the screen. It is the Indian Evidence Act 13th December 2022 and 14th December 2022. And please read and come to the class. Let the class be the participatory class, and that I wish wants to make it out. That is number 1. Number 2, as I told you now, if you don't give the reply, I told you that my tongue is tied, my hands are handcuffed, my legs are fettered, and hence you are supposed to give the answer to me either yes or no. If you don't know the yes or no, you can say at least pass on without wasting the time. So these are the things which I want to make it out. With this, I would like to wind up my class today. Yes, still it is there going on. Okay, I will wind up my class today. Thank you very much for patient listening. And now the end of the, I don't know where should I end it. Yeah, here can stop it. And end of the class. Jai Hind. सारे जहां से अच्छा हिंदुस्तान हमारा. जय हिंद.